Hello and welcome. I'm Bob Lee, the Executive Director of the Institute for Applied Management and Law, and I'd like to welcome you to an IAML alert. The topic is California pay equity law. The presenter is Gavin Appleby. Gavin Appleby has been teaching for the Institute for over 25 years. He is a partner in the law firm of Littler Mendelson, headquartered out of the Atlanta office. Gavin is a lead instructor for IAML programs from our Advanced Update in Employment Law to Workplace Decision Making to Investigations, the Certificate of Employee Relations Law, and our Essentials of Human Resource Management. This program is important for anyone who has California employees. Please listen closely for the next 8 minutes and the outline that you have in front of you for issues that Gavin feels important that you should address, from pay equity, wage theft law, retaliation, and others. Gavin, take it away.
I'll be happy to do that. Thanks for the introduction, Bob. And if everyone's wondering why a person based in Atlanta is dealing with California law, it's because I spend a considerable part of my life in California, and I'm doing a lot of compliance stuff around the country. And California, of course, is still part of the United States, but we sometimes wonder if the laws have gone into an alien country. But anyway, that's part of what we're doing here today. There have been a number of new laws passed in California. For those of you who live in California, you're probably aware Jerry Brown has the option at the end of the legislative session to veto or not veto. He's got a couple of weeks to look over those laws. And we now have what we have for the new year. The most major of those is the one that Bob mentioned, which is the California pay equity law. California, by the way, has had a pay equity law for a long time, back to 1949, if I remember correctly. And to make a long story short, I think the perception is, at least by those in the legislature, that the old law wasn't getting it done. And there may be some truth to that. I know that I do a fair amount of litigation in California, too. And the reality is we don't see that claim very often. Where the claim is made, it's usually made almost as a basis like a straightforward sex discrimination or race discrimination type claim. So the new law should be changing all that. It is very broad, and let me give you basically in a fairly small nutshell what you should be aware of and what you should be looking for. So the old law basically said simply this, which is that to have a differential in pay based upon sex, that could happen so long as it was justified by a number of factors. And the big issue in the old law, which is very similar to a federal law called the Equal Pay Act, is that you have to pay equal for equal work. California has now changed that, and that's the big deal. We haven't gone as far as we almost went about 20 years ago to something called comparable worth, which was the issue where as a nurse is valuable to somebody as a scientist, and therefore they should get the same pay, even though they're not remotely anywhere near the same job. We haven't gone that far at this point. What we have, though, is we've now changed the situation to the comparison is no longer equal pay for equal work. The comparison is equal pay for substantially similar work. With equal pay for equal work, we were able to basically evaluate the same job and two people, one male, one female, within that job, and at least you're working from an apple cart. Now, with the substantially similar language, we're working from an apple versus oranges and perhaps even pineapples analysis, because we're being asked not to just look at people within a particular job, but substantially similar could basically be a job versus another job versus maybe even another job. And that is going to create some very interesting pieces relative to this whole situation. Because once you get into this idea of substantially similar, what does that really mean? And how do we really define that? And the answer is I don't think we know, and I don't think the law tells us. What it does tell us that we have to look at a quote-unquote composite of skill, effort, and responsibility performed under similar working conditions. And I guess those are relevant factors, and I think they probably are relevant factors. But when you've got two similar jobs, you're going to have a little bit of difficulty evaluating what that means. And does that mean that Jill and Jose are really doing the same thing? Are they doing enough of the same thing? And frankly, we're probably looking at 10 years of litigation before we know what the courts are really going to say about that. The question becomes, are you going to be one of the test cases? And it is going to be interesting to see how they all play out. All this is based on that analysis, which California said actually within the law. The legislator talked about a differential in pay based on gender, and they talked about women making only 84 cents for a man made by $1. You probably heard a different figure, which is a national figure thrown out sometimes, of 77 cents or even 71 cents versus $1. The problem with those broad comparisons is we're not just apples and oranges. We're talking about grapes and watermelons in there as well. So it's very difficult to do that. Having said that, I do believe that there is a differential, and I do believe the differential was probably 10% or the sort right along those lines anyway. And so I get the justification for this law. I think the question is going to be the generality of substantially similar work, and you should be looking to determine how that might be measured. By the way, one way it's often measured in a company is to look at job grades, because we do see different jobs at the same grade. That may or may not be substantially equivalent work, but it may be one thing to look at. Secondly, might be the tasks that people do. Third is the amount of responsibility that they have. So you're going to look to see those issues. If you're going to look, I recommend you do it in an audit. I recommend you do that audit with attorney-client privilege so you don't have a potential disaster facing you if litigation occurs. I do a lot of those audits. So does my law firm, Littler Mendelson. And if you have an interest, obviously let us know. But that is probably the safest way to do it, is under attorney-client privilege. One other piece to this law you should be aware of that's also different. In the old law, we talked about within an establishment. Now we have something that says there is no same establishment requirement. And the worry about that is one that is a very, very big concern to me, and that is, are we now comparing Los Angeles with a small town in Northern California? And that could get very interesting very quickly, because we have always paid based upon geography and market. Everybody I know in the pay world does that. And I will tell you that if we're looking beyond establishments and we're saying that people just have to be paid the same, and we're not considering geography, that is a potential disaster for employers. I am hoping that the courts will understand that. I'm hoping that a bona fide factor other than sex also may include geography, but that is not in here very clearly. Two other things just to state about the pay law, and I will close that one up because I know we have a short period of time here. One is you also should be aware that the law brings into practice something new, which is basically a no pay secrecy policy, no pay secrecy requirements. That is really not new, because the National Labor Relations Board has been interpreting the National Labor Relations Act to do the same thing for about 8 years now, well, actually longer than that. But ultimately, the state of California decided they had to have their own law on that. So they specifically have in this law that you can't make people keep their pay a secret. You have to let them discuss that with other people. I don't think most people have an issue with that any longer. I think most companies don't have an issue with that any longer, but it is part of the new law. And then finally, the new law has an element in it that deals with burdens of proof. And effectively, what's now happened with the new law is that the burden for employers has gone up, the burden for employees has gone down. And that's going to play out in litigation at some point. The burden on employer now requires that the difference in compensation not be sex-based, and you have to specifically show that there is an element not based on gender that justifies the differential. It's got to be related to the position in question, and there has to be a quote-unquote business necessity that caused the differential to occur. That's a fairly high standard. And even then, by the way, the employee with a much lower burden can say, oh, by the way, there's an alternative way to pay people that exists, or alternative analysis that could have applied here, and if that alternative is less discriminatory, it should have been applied. And that's going to create a lot of confusion for the world's juries, because that's a very difficult issue. So in a nutshell, that's what we've got on that one. Be very careful. Like I said, I think it's worth looking at pay issues, looking to see how you are paying. The geography things should concern you. And if you are, two factors, I guess, moving forward. Make sure as you're evaluating pay that you are looking for bona fide factors such as qualifications, such as performance, such as seniority. And two, you really ought to be thinking about the audit issues, because that's the only way you're going to know if you do this right. And please don't do an audit without privilege, because that may be something that's going to appear in court against you. A couple other things California changed. There's numerous laws that came out. Most of them are relatively picky, relatively kind of nitpicking. There's a change that occurred on the retaliation law that you ought to be aware of. It now links family members. So if an employee is retaliated against because of a family member or vice versa's actions, that's not covered by the law. I'm not sure how important that's going to be. It's also kind of a weird one, and this one was intended to overturn a court decision. The question became, if someone requested accommodation either for religion or for reasons related to disabilities, and that accommodation was not reasonable and therefore was turned down, even though the accommodation requested was unreasonable, you can't retaliate against the person for having made that request. Not sure that's a big issue either, but it is something to be aware of. It is a nuance now that wasn't there in the law before, and I think as we go through the accommodation issue and how complicated that's become, you need to be aware with your managers that your managers not get stupid just because someone asked for something that they perceive to have been a stupid accommodation. And I have seen that happen from time to time. So that's the retaliation piece. Good news for employers, and this is really very good news because we thought it was going to just not happen, and that is the legislature this year also passed a law that would have prohibited arbitration agreements for new employees coming in. California arbitration agreements have become a huge thing because of all the wage and hour class actions that were going on. And we've got an awful lot of clients who are now sorting people out relative to arbitration agreements. And California legislature was about to completely dismantle that, at least for new people coming in. It passed, but Governor Braun actually vetoed that as a quote-unquote job killer bill. And that's a relief for everybody. You should be aware of that. And then finally, next year is always another year, and maybe not too surprisingly, new bills are already piling up, and they range from increasing the state minimum wage to further expanding some of the discrimination laws. But amazingly enough, there's already 10 laws that are projected out there as requested and sought laws that will be coming before the legislature, all dealing with marijuana. Very interesting. They run from broadening medical marijuana to making marijuana legal, and one even, by the way, would preclude employers from drug testing for marijuana, which is a very interesting issue if you happen in the construction world or something like that. But that's still to come. We'll be talking at this point next year and seeing what came through, and it could be very interesting. I hope this has been helpful. I appreciate the time you spent with me, and thanks for checking in on the IAML website.